Okay, thank you. And hello, everyone. A warm welcome to all of you joining us today to hear about the GNHRE's implementing principles for the Escazú Agreement by a fantastic panel of scholars. This session is expected to last 90 minutes. The webinar will last approximately 1 hour, and then we'll have time for Q&A at the end. And we would like it if you could type in your questions in the chat box. And if you want to direct the question to someone in particular, please do mention it in your question. So now let me first introduce you to Dina Lupin and Héctor Herrera, who will be giving the opening remarks. Dina is the director of the GNHRE and a lecturer at the School of Law at the University of Southampton in the United Kingdom. In her current research, she examines the way in which indigenous communities are subjected to practices of silencing and epistemic injustice in consultation processes, and in the ways in which these communities resist and subvert oppressive practices. Héctor Herrera holds a law degree from the Universidad de los Andes in Colombia. He has a master's in public policy from Colombia's Universidad Nacional. He is the co-founder and external advocacy advisor of the Observatory for Marine and Coastal Governance in Colombia. And currently, he is a researcher at the Institute of Development Policy at the University of Antwerp in Belgium on climate finance with a climate justice perspective, and the director for Latin America of the GNHRE. Dina, the floor is yours.
Thank you, Natalia. I am very happy to be here in this very intimate space. And I'm also going to be letting people in, so I apologize for that. As Natalia said, I am the director of the Global Network for Human Rights and the Environment, and it's in that capacity that I'm joining this panel tonight, and it's in that capacity that it is my great honor to welcome you to this launch today, and to tell you a little bit about the Global Network. I'm not going to talk for long because I'm not really the one we're here to hear from. So, on behalf of the GNHRE, I warmly welcome you to what feels like an historic event. It's the launch of the GNHRE implementation principles for the Escazú Agreement, but we're particularly delighted that it's taking place as a side event to this historic first conference of the parties to the agreement. There couldn't be a better time. Although there maybe could be a better time, there couldn't be a better moment for us to be launching these principles. The Global Network for Human Rights and the Environment is a network of thinkers and researchers and policymakers, opinion formers, community activists, community activists, defenders, who come together, who engage with each other, and whose diversity forges new conversations, new relationships, new ways of thinking about human rights and the environment. We produce, we exchange, we learn from scholarship, from advocacy, from the insights of community-embedded experience and praxis, really at the interface of human rights and the environment all over the world. And as a network, particularly led by Maria Antonia and Daniel, we were very excited about the Escazú Agreement. And we really felt that the entry into force of the agreement was a groundbreaking moment in many ways in the history of international law on human rights and the environment. And I think what we wanted to do as a network was recognize this remarkable achievement for what it was, the result of extended struggle and activism by not just sort of policymakers, but by communities and individuals across the region whose lives and livelihoods have been threatened by environmental degradation, and to believe as so many of us in the network kind of do, that rights to access to information, participation, and justice are really the foundations of addressing that threat, and are essential to recovering the diverse, complex, and reciprocal relationships that people in the region have to the environment. And as a result, of our kind of recognition of the importance of this agreement, we also saw that the importance of effective implementation of this agreement. And led by Maria Antonia Tigre and Daniel Nerona, the GNHRE launched a multifaceted project of which these principles is just a part, and I would encourage everyone to go and have a look at our website, to look at the blog posts, to read about the meetings and workshops that happened. And it's been a fantastic and important engagement with the agreement, I think. And today is really, we're going to be talking about the principles, but the team have put together a remarkable body of new work, of readings, and I would encourage you all to go and have a look at that. And I'm going to hand over to Hector, but I just wanted to say a heartfelt thanks to all of those who've worked so hard on this project, and especially to Maria Antonia, who's put in hundreds of hours, I think, into this project, to Daniel as well, whose work on this has kind of been squeezed in amongst all the million demands of life, as have been Maria Antonia's. It's just been tireless. To Natalia, whose contributions have been kind of invaluable in making this happen. To Felix Leroux, to Lavinia, to Pablo, to our intern Will, who's been helping with the website side of things, and to Gaston, and to Hector and Claudia, who've taken over the role of leadership of the region for the Global Network for Human Rights and the Environment, and have sort of embraced this project so warmly and hit the ground running to make it happen. Thank you to you all, and I'm really looking forward to hearing what you've got to say today.
Thank you, Dina, and thank you everybody for all this effort, this collective effort to create these principles and to contribute to the debate and the implementation of the Escazú Agreement with those. Yeah, and I also wanted like to invite like people interested on this, like maybe watching this in the YouTube channel or in other platforms, interested on this, to go and visit the website of the Global Network of Human Rights and Environment, and be in contact. Maybe if you're interested to be part of the network, because this network is a collective effort. It's such a good place to be in contact with other academics, practitioners, and learn and share knowledge and share experience. And it's been like a very educational space to me, and I know for most people, it's for all the people in the network, is a fantastic space. And I also wanted to mention like what couldn't be the best day to launch the principles than today, day of Planet Earth, April 22. We are celebrating, you know, our common interest on defense of the environment, on defense of our mother, La Pachamama, planet Earth, and that's it couldn't be a better date, better time to launch the principles. And yeah, actually just wanted to mention like all the time we're having progress in the defense of the right to a healthy environment, in the defense of the planet Earth, just like with the Escazú Agreement, or like yesterday in Colombia, like Judge Blanca Martinez recognized the right to a prior consultation of a Afro-Colombian community, and ordered the suspension of a pilot project of fracking of non-conventional hydrocarbons in Colombia. Like I am optimistic, and I think like all these kind of contributions, the principles today, like it's step by step that we are like making progress in defending planet Earth and the right to a healthy environment. So I'm really glad that you are here. Like these principles have been launched, And just wanted to reiterate like the invitation to participate, the invitation to join the network, and yeah, that's like the invitation, and I want to emphasize. And I now like let continue the space with Natalia Ursola, who is a Colombian lawyer and a Colombian attorney. She's currently serving as a Chief Operating Officer of the Global Network of Human Rights and the Environment, and she will continue like now in charge. Thank you.
Thank you, Hector. Okay, so now let me introduce you to Maria Antonia Tigre and Daniel Noroña, who will provide an overview of the process that brought us the GNHRE implementation principles. Maria Antonia serves as the Deputy Director of the Global Network of Human Rights and the Environment and is the Global Climate Litigation Fellow at the Saving Center for Climate Change Law at Columbia University. Daniel Noroña is a lawyer from Ecuador with an LLM in environmental law from Tulane University. He currently serves as a consultant for the Office of the Special Rapporteur of Economic, Social, Cultural, and Environmental Rights of the Inter-American Commission of Human Rights. Previously, he worked for the Attorney General Office and for the Ombudsman Office of Ecuador. So Maria Antonia, if maybe you could start, you can unmute yourself.
Thank you so much, Natalia. I think, welcome everyone. First of all, I share what Dina and Hector said on the momentous time that we're launching the principles and participating in this first conference of the parties on this Earth Day, which is pretty incredible. This process has been going on for about, I think, 9 months since sort of the middle of last year, that when Daniel and I sort of got together, as I was the director for Latin America for GNHRE at that point, and we really wanted to do something related to the Escazú Agreement as this, incredibly incredible agreement that was adopted for Latin America and the Caribbean, and understanding a little bit of the challenges in implementation that the region usually faces. We were thinking about how we could sort of support a little bit that process, and we came up with this multifaceted project, like Dina mentioned, that started as a blog symposium. We had contributions from 12 different posts. Some posts were written jointly by 2 people. So it's a really sort of rich conversation that kickstarted some of the challenges in implementing that, and sort of what we could do as this network to support that process. So after, the blog posts were published throughout several months, and in between that we held this virtual summit, which went on for 2 days. So the first day we had like a high-level panel with some amazing speakers: Soledad Garcia Munoz from Redesca, David Boyd, the Special Rapporteur on Human Rights and the Environment, Marcos Ordelana, the Special Rapporteur on Toxics and Human Rights, and Lina Avila from Bogota, and Jovita Tsutzul from, who's an environmental defender and a lawyer for indigenous groups from Guatemala. So, they sort of provided an overview of the big challenges at the high level. And then on the next day, we had a smaller workshop with some invited people to actually debate some of those issues that we wanted to focus on and that we thought would be challenging. That process, throughout that process, we created a task force, and we worked on for several months to actually draft the principles with a really incredible group of people. So, that's how we got to this point right now. And now I think the most important piece now is the principles themselves. So I'll leave to Daniel to explain those. So thank you to everyone who was involved, and it's a pleasure to be here.
Thank you, Maria Antonia. Daniel, do you want to add?
Thank you, everyone, and thank you, everyone who's listening and gonna see the recording eventually. So it's my pleasure to be part of this process. As Maria Antonia, as Natalia said, my name is Daniel Noroña from Ecuador. And what I'm gonna do is basically do a little overview of what the principles include, what are certain of the advances, And I think it's crucial that we're doing. I just want to reiterate the importance that this is coming during the COP of the agreement, and also on Earth Day, on the day of the Pachamama, which I think it's more relevant ever. So in that sense, what I just basically want to say that the principles are founded on the idea that the interpretation of the agreement must lead a focus on the expansion of human rights, and the certainty that any interpretation that arises from the states will follow that line and basically have a full human rights approach. In this sense, the principle is divided into seven. The principles are divided into 7 sections, each one focused on the different issues that the agreement dives to in its different articles and sections. It is important to note that the principles come as an aid to policymakers, basically a tool for policymakers, judicial authorities, civil society, and different stakeholders in the process of implementing the dispositions of the agreement. Therefore, we have to take note that the introduction of the principles provide a general overview of the state of the art and a brief diagnosis of the situation on the region. In this very brief introduction that the principles have. Hence, the principle already reiterates that beyond the agreement, the states are already bound by international and regional human rights law. So in that sense, the principles and the agreement basically becomes like an extrapolation of previous human rights law and inter-American human rights law, especially. Further, the general principles that we have in that part of the principles, basically, not trying to be redundant, recognize that any interpretation of the agreement cannot interpret provisions that will hinder the effective application of rights. In this sense, we call for the use of the principle of non-regression and the progressive realizations of the rights, which is also part of how we view basically economic, social, cultural, and environmental rights, looking into like this progressive obligation that these type of rights have, and also the immediate application, for example, of the principle of non-discrimination and equality. Also, it's important to understand that this also furthers the content of the agreement by also invoking aspects that come from the Vienna Action Plan of Human Rights, such as the application of the principles of indivisibility and interdependence, because there's certain principles that dive into the application of those areas. Following that, the next section of the principles pertain to the right to a healthy environment. What basically does this part of the principle is that it recognizes and it guarantees that protecting this right is vital for the implementation of the agreement. Basically stating that the core of the agreement is the right to a healthy environment, especially the procedural part of the right to a healthy environment. Since it's important that whenever we interpret the agreement has to be to further access rights and to guarantee them in any way possible by any measure of the state can make, either a public policy, a norm, or even by the decision of its judicial bodies. The next 3 sections of the agreement look into the different access rights. It is important to note that the principles further what is already stated in the agreement and certain other additional definitions. Here, I think, and something that is also important to note, and I want to thank my colleague Claudia for stating this earlier, is about that in all these previous part of the principles that look into the general application of the agreement and providing the amplitude of a human rights approach, we also make a differentiated approach also based on gender, and how that also relates to the importance of how do we apply different differentiated measures towards the application and implementation of the agreement, which is also, I think, recognized very important. Coming back to the issues pertaining to the access rights, we know that the principles refer to Articles 5.7 and 5.9 of the agreement, because it states, especially when it comes to access to information, what's the test that needs to be implemented when we want to say that this information cannot be provided. When is that a special exception that states can make? And I think it's very important to decide what will be or to have an idea of what can be the test or the principles that, more than the principles, the test that can be activated in order to the state to basically for the states to basically give an exception to the rule of providing the information. And basically, what we have here is that the states must show that there is a legitimate interest they're pursuing, that this is necessary, and of course that the harm of getting the information outweighs the public interest. Um, for this, what we have is, for example, a strong jurisprudence in this matter from the Inter-American human rights system that comes from the Clark-Reyes case or the Inter-American model law for the access of information. Respect to participations, we have principles 10 to 15 that basically underscore the need for an inclusive, transparent, and fair participation process, and in basically in all decision-making processes. It talks about the respect and the need to enforce the standards of the prior previous informed consent, free prior informed consent from indigenous populations, and also indicates that the obligation to secure participation, and I think it's important on how the principles are advancing on interpretations from the agreement, pertaining that the states are not only the ones obliged to give this information, but for example, puts obligations towards businesses, looking into like an application also the business and human rights principles. Finally, also principles 16 to 19 is basically going to access to justice. Further, what does it mean to have a strong judicial system that promotes fair access to justice and peaceful conflict resolution? And that in order to achieve this goal, basically, we are looking into fostering capacity building for judicial system staff and personnel. And I think that's crucial because we're not also looking into the legal solutions, but also from a policy standpoint of the judicial system. And I think that's also vital on how we wish to have an appropriate local implementation of the agreement, because this also comes into the next aspect that needs to that talks about environmental defenders, which goes into principles 20 to 22. And basically what it means is in that aspect is that environmental defenders play the crucial role of protecting the environment and being the first line of defense of the environment in this sense. So basically what we are looking into the principles and what those principles state to is that part of the tools that we can have to track the effectiveness of the of this part of the agreement is by, for example, resting on data, utilizing different tools that we have at our availability, that basically we look into creating this type of systems. So we're looking about systemic solutions. We also looking into this, like an importance, we highlight the importance of national human rights institutions as a vital partner to secure this type of obligations. And obviously this falls into and is connected to the previous part of the access to justice, because we cannot secure the protection of environmental defenders. Also, we don't have a strong rule of law, independent investigations, that prosecutors do their job, and basically they have a due diligence investigation towards threats of environmental defenders. So that is interesting. And finally, the last section of the principles, and I think it's the longest because it's one of the, perhaps of one of the points where we can say some that may come a lot due to different issues, is going to be the part regarding cooperation, which goes from principle 23 until the last principle, which is principle 31. So in this in this part, we point out of how this cooperation will look into a regional security for environmental defenders. That's my view, especially because when we're looking into the cooperation of different actors, not only states, but other international organizations, it's gonna look into how effectively the states cooperate to properly, for example, provide information needed to track the protection of environmental defenders, to track how environmental democracy is going on, and I think it's important. And what I think is important is that in this chapter, we also, in this section, actually, we look very into that cooperation that I was mentioning, because it's inevitable that the compliance mechanism, the compliance committee, will definitely have a lot of interaction with human rights protection mechanism, especially the Inter-American human rights system, and of course also the universal system. Principle 27 looks into that, and it's important because that principle basically states that the countries cannot see that a presentations of a claim before the committee should be seen as a waiver of accessing other protection mechanisms, whether it be universal or inter-American. So I think that's important to figure it out. And also, I think it's important on the relationship we have, especially with the inter-American system, and this will be the last thing, is because we have to remember that the Inter-American Democratic Charter in Article 15 states that one of the main ways to defend democracy and part of the democratic order is also the protection of the environment. So I think there's a strong normative background or justification to see why this is also going to affect inter-American relationship and especially inter-American normative. So this will be interesting to see how this will play out. So basically, I think this is gonna be my end application. I hope intervention. I hope it wasn't running too fast, but I'm very concerned of the time. But finally, this is just to say that this is this text is a text that is alive. So I think it will be constantly evolving. But I think the foundations are very strongly built. So in that order, I would like to thank everybody and thank you, Nati, and thank you, Natalia.
Thank you, Daniel and Maria Antonia. That was clearly a very impressive effort that you put together, a fascinating process with an impressive output. I mean, the principles are very comprehensive and I must say also ambitious, but in a good way. So we will now hear from Gaston Medici Colombo, who will comment on the principles themselves from his position as collaborator. Gaston is a lawyer from Argentina, currently working at the environmental law consultancy firm InstaJuridic in Spain. He is also an associate researcher at the Tarragona Center for Environmental Law Studies. Gaston holds an LLM in environmental law and a PhD in law, and his work has mainly focused on climate change litigation and environmental access rights. Gaston, the screen is yours.
Thank you very much, Natalia. Thank you very much to all the team of the Global Network for inviting me not only for today, but to participate in the entire process. It's a pleasure for me to be in this event that, in a way, closes the COP week and addresses the most relevant issue for this new era of environmental democracy in the region, the implementation of the Escazú Agreement. These days, several events were devoted to this topic, and this attention in implementation surprises no one. In the end, implementation and compliance are the biggest challenges of environmental law in general, and access rights are not the exception. The organizers asked me to spend the next few minutes offering some comments about the principles, and of course there is too much to say. As Daniel explained, it's a detailed document that addresses a relevant part of the content of the agreement. So I decided to focus my intervention just on two ideas that are behind the reasoning of several of the principles and that I consider key when thinking about the implementation and future development of the agreement. The first idea relates to the synergy between the Escazú Agreement and human rights law, and especially the inter-American regime. The second idea relates to the continuing relevance of the Aarhus Convention experience for this new stage of the Escazú regime. So I will develop just a bit, these ideas, providing some examples to illustrate them. So, in the first section, the implementing principles, among other things, refer to this synergy between the agreement and human rights law, specifically mentioning the Inter-American system to which most of the states of the region belong. This relates to the fact that the Inter-American bodies have been developing human rights standards connected to environmental protections for a while. Standards that, to a large extent, have been condensed in the advisory opinion of the Inter-American Court. The Escazú Agreement, in a way, came to systematize, complement, and further develop part of these human rights standards. However, where the agreement falls short, those standards designed by the Inter-American bodies become relevant and should be considered and used to interpret and implement the agreement. Let me give some examples included in the implementing principles. The second section of the principles establishes that those in charge of the implementation of the agreement should consider that the right to a healthy environment recognized in Article 4 not only implies the protection of nature as an interest to humanity, but as a legal interest in itself, even in the absence of certainty or evidence of risk to individuals. This more ecocentric view is not recognized in the language of the agreement. In fact, based on what happened in the negotiations, one can argue that an anthropocentric view actually prevailed. In the last meeting of negotiations, a suggestion to include the principle pro natura as part of the principles of Article 3 was rejected by some negotiators and the discussion dismissed. On that occasion, the public expressed concerns about the imbalance that this absence and the presence of the principles pro persona could create in the implementation of the agreement. This could give the impression that the more ecocentric view proposed in the implementing principles does not have support. However, that's not right. The implementing principles replicates the interpretation done by the Inter-American Court in its famous advisory opinion when referring to this right as included in Article 26 of the American Convention. In this way, this interpretation allows for a less anthropocenic view of this right in the implementation of the agreement, overcoming a possible shortcoming. Another example. In the 7th meeting of the Escazú negotiation in Argentina in 2017, the standards established in the draft text regarding the refusal of access to environmental information were seriously softened. A numerous clauses list of exceptions, like that provided by Aarhus, was rejected by the negotiators, who decided instead to leave latitude to domestic legal orders. This deletion was described as a very worrying regressive development by the public. However, it gave place to the inclusion of a provision that explicitly asked parties to take into account their human rights obligation when establishing their exemption regimes. And this is really relevant since the Inter-American bodies have designed very detailed criteria regarding the refusal of access to environmental information, and all these standards mentioned in the implementing principles, as Daniel explained, should be seriously considered by public authorities when designing or assessing the national exception regime as part of the implementation of the Escazú Agreement. A final example of this synergy. Some scholars have criticized the definition of public given by the agreement in Article 2, which refers to persons or associations that are nationals or that are subject to the national jurisdiction of the state party. They have fairly described this definition as discriminatory for those beyond borders, especially in the context of transboundary environmental impacts. For them, this is in direct conflict with the own agreement's principle of non-discrimination and with international law in general. Before these situations, Once again, the Inter-American regime can offer a solution. In the mentioned advisory opinion, the court interpreted the scope of the word jurisdiction in Article 1 of the American Convention in a broad sense in order to determine a state's obligations regarding environmental protection, including those affected by acts controlled by the state with effects even beyond its borders. If we interpret the agreement definition in this sense, as I think it should be done, the concerns posed by these scholars about the discriminatory nature of the definition can be overcome. The second idea, as I mentioned, is the continuing relevance of the Aarhus Convention for this stage of implementation of the Escazú Agreement. And I will refer just to two examples. The first one relates to the interpretation of a provision regarding participation in environmental matters. Article 7.4 of the Escazú Agreement establishes that parties shall adopt measures to ensure participation from the early stages. However, the agreement does not define what early stages mean, raising concerns about an ineffective implementation of this right. In this sense, the language used by the Aarhus Convention can give us an answer. Article 6.4 of the Aarhus Convention contains the phrase, "when all options are open." This phrase, the implementing principles argue, should be used to interpret the Escazú provision in its implementation, overcoming at least partially the mentioned risk. The second and last example that I want to give refers to the Aarhus Compliance Committee. Its composition and functioning, and specifically the possibility of the public to submit direct communications to trigger compliance proceeding, are all key elements that have defined the relevance of this entity for the Aarhus regime. To put in perspective, 200 proceedings have been opened before this body so far, of which 191 were triggered by the public. This experience obviously has a lot to offer to the development of the Escazú regime, as the implementing principles note. Luckily, or better, as a result of the great work of the negotiators and the public, yesterday the Conference of Parties adopted rules for the Escazú Committee that include all the main elements that made the Aarhus Committee a reference. We can expect then that the future work of the Escazú Committee will be as relevant as the work of the Aarhus Committee for the development of access rights. I'm going to stop my intervention here with this optimistic view. And of course, any question is really welcome. Thank you.
Thank you, Gaston. Those are very important and key issues that you have raised. Our last panelist, Claudia Ituarte Lima, will now provide some comments regarding the UN Secretary General Call to Action for Human Rights. Claudia Ituarte Lima is Deputy Director for Latin America at GNHRE and Senior Researcher at the Roel Wallenberg Institute of Human Rights and Humanitarian Law. She is also affiliated to Stockholm University and the University of British Columbia. Claudia, the floor is yours.
Thank you. Thank you, everyone, and great presentations. I'm greeting you from the COP, from the Escazú COP in Chile, which has been like amazing 3 days of inspiring, tense, and a mix of everything. But I think everybody comes out really empowered and really thinking of, when we refer sometimes to Latin America and the Caribbean, there are stories of poverty, disasters, migration, and so many things that, of course, affect Latin America and the Caribbean. But there is another story, a story of success, a story of solidarity, a story of multilateralism, that I think it's the story that we're hearing today at the Escazú COP. So I would like to link like the very important discussions that we have had so far in terms of the implementing principles of the Escazú Agreement with this global UN Secretary General call for action on human rights. And why? Well, as we all know, socio-ecological challenges go beyond borders. And this triple crisis of biodiversity loss, climate change, pollution that affects us all are of a global nature, although of course they have very concrete direct manifestations. So I would like to raise 3 issues. The first, how can the Escazú Agreement allow us to reimagine multilateralism and decision-making? Of course, we have a top-down process, but what Escazú Agreement has shown us, and very successfully, is that a combination of this top-down process with a bottom-up process can allow decision-making that benefits all. The Escazú Agreement, how it came about, it was a demand by society. It's a treaty by Latin American and Caribbean people and for Latin American and Caribbean people. And the public has had a key role during all the process of negotiation. And now there are very concrete mechanisms for the continued participation and make it work in practice. So that would be my first point. And I think it's quite relevant that this process of reimagining how we deal with multilateralism can have key lessons learned, not only for Latin America and the Caribbean, but also for other countries, for other regions, for Africa, for Asia, for the same Aarhus Convention. It wasn't the history of the Aarhus Convention, this so strong participation during the whole process of negotiation. So I think it's also, as Gaston mentioned, there are many lessons learned from the Aarhus Convention, but conversely, there are significant lessons learned from the Escazú Agreement to the Aarhus Convention. My second point, environmental rule of law, a key challenge for multilateral environmental agreements. We see, for example, in 1992, we have the adoption of the Convention of Biological Diversity. And there has been so many efforts to try to bring compliance to this key treaty that it goes beyond the conservation of species. It's about ecosystems, services of the foundations of life. And we see that the Aichi targets that were supposed to be complied with by 2020, not a single of them has been fully complied with. So this is really serious, and there's not yet a compliance committee within this convention. So here, the experience again of the Escazú Agreement that just with a lot of, I think, effort from all the negotiators, but finally got adopted. Its review committee and compliance committee for implementation. So environmental rule of law, as we know, it's at the heart of the human rights obligation to respect, protect, and fulfill human rights related to a healthy environment. So this compliance committee, as was mentioned before, would allow this combination of top-down and bottom-up approaches to be done in a successful way. Of course, there will be many challenges to make this work, but I think there is very good intentions to do so. My final point, the extent to which we embed intersectionality in the implementation of the Escazú Agreement, in my view, is the extent to which we will achieve this transformational change. This transformational change that is called by the Intergovernmental Platform Biodiversity and Ecosystem Services, that is called also by the Intergovernmental Panel on Climate Change, which recently released a very important report. It is called by the Sustainable Development Goals and Agenda 2030. But how do we do that? I think the Escazú Agreement, again, although it's a regional treaty, gives global lessons. And intersectionality, why? Well, because there are intersecting ways if we're going to implement an agreement. If you're an indigenous woman, it would be very different if you're a policymaker. If you're a lawyer, you will have different knowledge and experience. Probably that in certain circumstances, one will be better than another. So everybody has knowledge, has very important knowledge, and this has very much been recognized within the context of the Intergovernmental Platform on Biodiversity and Ecosystem Services. So this twin reality of some groups, such as children, women, indigenous peoples, and local communities, yes, being vulnerable in many situations, but at the same time, being agents of change. Many times, really on the forefront, as we have seen environmental human rights defenders. And it was very inspiring to hear the discussions around the Declaration on Environmental Human Rights Defenders and this emphasis on including intersectionality in terms of, I mean, in Spanish, making sure that it's defensoras and defensores, that this is very explicit. There's an explicit reference also to indigenous people and local communities. So I would like to end with that. It's really inspiring, I think, to be in this moment and to be from Latin America and really feeling this pride of being from here. Although much of my work is global, I feel very much my heart and I think a lot of inspiration from what's happening here. Thank you.
Thank you, Claudia, and I can agree with that. We are now going to open up for questions. I don't know if we have questions from the audience. I cannot see. Hector?